What started as an ordinary day at a Florida resort pool spiraled into a nightmare that would land a mother behind bars and leave a young boy traumatized. This is the story of how a moment of rage transformed a vacation into a criminal case, and how the justice system responded to an act that crossed every boundary of acceptable behavior. The scene was the Gaylord Palms Resort near Orlando, a place where families come to escape, to relax, to let their children splash and play in the sunshine. The sounds were familiar: kids laughing, water splashing, the carefree noise of childhood joy. But on this particular afternoon, those sounds would give way to something far more sinister. Two 6-year-old boys were playing in the pool, doing what 6-year-olds do: dunking each other, splashing, engaging in the kind of rough play that sometimes gets out of hand. One boy dunked the other beneath the surface. It was aggressive, perhaps, but still within the realm of children being children. What happened next, however, was something entirely different. 36-year-old Tiffany Griffin was at the resort with her own child, and when she learned that her son had been dunked underwater, something inside her snapped. According to witnesses and security footage, she didn't simply separate the children. She didn't speak to the other boys' parents. Instead, she made a choice that would alter the course of her life and traumatize a young child. Griffin entered the pool. She appeared calm at first, moving through the water with purpose. But what she did next became the focal point of a criminal investigation that would shock everyone who learned about it. She approached the 6-year-old boy from behind. She placed both hands on his small shoulders. And then she forced him underwater. Not for a brief moment. Not an accidental nudge. For 2 to 4 seconds, she held that child beneath the surface. To an adult, 2 seconds might seem insignificant. But imagine being 6 years old. Imagine someone you don't know suddenly grabbing you, forcing you down, holding you under. The terror that must have coursed through that little boy's body is almost unimaginable. When he finally fought his way to the surface, gasping and panicked, he ran. He ran to his parents, but he wasn't just crying. Blood was streaming from his nose. The physical evidence of what had just happened was literally pouring down his face, staining the towel his mother would use to stop the bleeding, a towel she would later photograph and submit to investigators as evidence of the assault on her child. But the incident didn't end there. Griffin wasn't finished. As the boy reached his family, sobbing and bleeding, she followed him. She began yelling, screaming justifications for what she'd done, claiming the boy had pushed her child. And then she did something that speaks to a complete lack of awareness of the severity of what she'd just done. She pulled out her phone and began recording the family, shoving a camera in their faces as if she were the victim in this situation. The boy's mother stood there, confronted by this woman who had just assaulted her child, now being filmed without consent, watching her son's blood seep into a towel. The boy's father, who had been sitting nearby in a beach chair while the children played in the shallow 2-foot section of the pool, tried to process what had just happened. His son had returned from the pool crying, bleeding, terrorized. Other guests at the resort watched in horror. One witness would later tell deputies that he had seen the entire thing. He described how Griffin, wearing a black 2-piece bathing suit, had calmly entered the pool, positioned herself behind the child, placed both hands on his shoulders, and fully submerged him underwater. He estimated it lasted 2 to 4 seconds. Another witness came forward to tell the boy's father that they had seen a woman attempt to drown his son. The resort's security team was alerted immediately. What they had initially heard as a verbal disturbance quickly revealed itself to be something far more serious: a possible drowning incident. They identified the room Griffin was staying in and pulled the security footage. What that footage captured would become the centerpiece of the criminal case against her. The video showed the children playing and splashing as children do. It showed Griffin in that black bathing suit entering the pool. It showed her approach the children and splash them. And then it captured the critical moment: Griffin approaching the boy from behind, placing both hands on his shoulders, and forcefully submerging him underwater. The timestamp read around 4:22 in the afternoon. The duration, approximately 2 seconds. 2 seconds that would change everything. Deputies arrived at the scene to find a chaotic situation. Parents were angry, accusations were flying, and at the center of it all was a 6-year-old boy who had just experienced something no child should ever have to endure. The investigating deputy first spoke with the boy's mother, who explained how her son had emerged from the pool crying and bleeding. She described how Griffin had approached her immediately after, yelling and recording her with a phone, until a man with a child, presumably Griffin's husband and son, pulled her away. The boy's father gave his statement in Spanish, explaining that he had been sitting in a beach chair watching the kids play when his son returned, crying with blood coming from his nose. Griffin had followed his son, he said, yelling that she had pushed him because the boy had pushed her child. Then another guest had approached to tell him they had witnessed the same woman attempt to drown his son. The pieces of the investigation came together quickly. Multiple witnesses, security footage, photographic evidence of the boy's injury. And all of it pointed to one conclusion: Tiffany Griffin had committed aggravated child abuse. She was arrested and taken to the county jail. The charge was a felony, not a misdemeanor, not a citation, but a serious felony that carried significant potential consequences. And when she appeared before a judge for her arraignment, the severity of what she had done became crystal clear. Her defense attorney attempted to minimize the incident, suggesting that holding a child underwater wouldn't necessarily cause the kind of injury the boy had sustained, the nosebleed. He implied there must have been some other action between the submersion and the injury that could explain the bleeding. It was a defense strategy certainly, but one that backfired spectacularly. The judge's response was pointed and revealing. She questioned the attorney directly. Didn't he think that placing both hands on a child's shoulders, forcibly submerging him underwater, and holding him there was sufficient to cause injury? The attorney tried to continue his argument, but the judge's tone made it clear what she thought of this defense. The attorney, recognizing he was losing ground, withdrew his argument. Then came a moment that crystallized the gravity of the situation. The judge turned directly to Griffin and laid down the conditions of her confinement. While she remained in jail, she could have no contact with the victim or the victim's family. Did she understand? A quiet, subdued voice responded from the defense table. Yes, ma'am. It was perhaps the first moment since the incident that Griffin seemed to grasp the full weight of what she had done. But here's what made this case even more unusual. Griffin was being held without bond. In many jurisdictions, a first-time offender charged with a crime of this nature might be released on their own recognizance or given a reasonable bond. People charged with attempted murder sometimes walk free by the afternoon. But Griffin would remain behind bars at least until her next court appearance. The judge's decision seemed to reflect not just the severity of the act itself, but the defendant's complete lack of awareness about the wrongness of her behavior. As legal experts analyzed the case, they pointed out the various levels of discretion that exist within the criminal justice system, and how Griffin's case had navigated through each one in the worst possible way. At the first level, police officers have some discretion in how they handle incidents. But in this case, that discretion was severely limited. This was a felony. There was a clear victim, a child. There were multiple witnesses. There was video evidence. And crucially, the victim's family wanted to press charges. The responding deputies had no real choice but to make the arrest. At the second level, the district attorney's office has discretion in how to charge cases. They could have reduced the felony to a misdemeanor. They could have declined to prosecute entirely. But they reviewed the evidence, the witness statements, the security footage, the photograph of the bloody towel, and determined that the charge of aggravated child abuse was appropriate and sustainable. They filed the felony charge. At the third level, the judge has discretion in setting bond and conditions of release. And it was here that Griffin's defense attorney's approach may have sealed her fate. By minimizing the injury to the child, by suggesting that the nosebleed couldn't have been caused by being held underwater, the attorney may have inadvertently angered the judge. The result? Remand without bond. Griffin would remain in jail. The case sparked heated debate online and in the community. Some people questioned why the 6-year-old boy who had dunked Griffin's child wasn't also being held accountable. One commenter asked if the juvenile was in custody. Another responded that no, he had simply cried to his mother when someone else taught him a lesson his parents should have taught him. These commenters seemed to side with Griffin, viewing her actions as justified retaliation for her child being bullied. But others saw the situation very differently. They pointed out that children make mistakes. That's part of being a child, part of learning and growing. An adult, they argued, should never put their hands on someone else's child. The difference between two 6-year-olds engaging in rough play and an adult physically assaulting a child is not just significant. It's the difference between kids being kids and criminal behavior. From a law enforcement perspective, the distinction was clear. When it's two children involved in rough play, officers have options. They can talk to both sets of parents. They can explain what might happen if charges are pursued: juvenile detention, juvenile records, officers visiting homes. They can offer both families the chance to resolve things without involving the criminal justice system. Often, cooler heads prevail, and the matter is settled without arrests or charges. But when an adult assaults a child who is not their own, the calculus changes entirely. This wasn't two kids splashing each other. This was a grown woman who sought out a 6-year-old child and physically attacked him. She didn't act in the immediate defense of her own child. She deliberately went after another child as punishment, as retribution, as a lesson. And that's where understanding gives way to culpability. Yes, parents are protective of their children. Yes, it's natural to feel angry when you believe your child has been wronged. But part of being an adult, part of being a parent, is maintaining control even when emotions run high. It means being the mature person in the room. It means talking to the other child's parents, not attacking the child yourself. As investigators pieced together what happened, they considered whether alcohol might have been involved, whether Griffin had simply stopped thinking rationally in the moment. But even if those factors were present, they didn't excuse what she did. They might explain it, contextualize it, but they couldn't justify it. The injury to the boy, the nosebleed, became a crucial element of the case. At the arraignment, the defense suggested that being dunked underwater wouldn't cause a nosebleed, implying there must have been some other cause. But the reality is that the child was bleeding, and it happened immediately after Griffin held him underwater. Whether the blood came from the force of the submersion, from the boy struggling and hitting his face, or from the sheer stress and panic of the moment, the injury was real and documented. And the law is clear. The duration of the assault matters, but so does the fact that it happened at all. 2 seconds, 4 seconds, 30 seconds. Once an adult places their hands on a child and forcibly submerges them in water, we've crossed from discipline or lesson teaching into criminal assault. Any amount of time holding a child underwater who isn't your own, without the parent's permission, against the child's will, constitutes an attack. The case also highlighted the importance of physical evidence in the modern age. The photograph of the bloody towel provided tangible proof of injury. The security footage captured the act itself, removing any ambiguity about whether it happened or how it happened. Witness statements corroborated the video evidence. Together, these pieces built an unassailable case. But perhaps most damaging to Griffin's defense was her own behavior after the incident. Instead of immediately apologizing, instead of showing remorse or recognition of how wrong her actions were, she followed the crying, bleeding child and confronted his parents. She yelled at them. She recorded them with her phone, as if she were building a case against them rather than recognizing that she had just committed a crime. That behavior, aggressive, defensive, lacking any semblance of remorse, likely influenced how everyone involved in the case viewed her actions. The responding officers saw a woman who showed no understanding of the severity of what she'd done. The prosecutors saw someone who needed to be held accountable. And the judge, when confronted with a defense attorney who minimized the child's injury, decided that this defendant needed to remain in custody. Legal experts analyzing the case noted that if Griffin had approached the situation differently from the moment police arrived, the outcome might have been different. If she had immediately apologized profusely, if she had shown genuine remorse and horror at her own actions, if she had acknowledged that she'd lost control and done something terrible, the police might have had more discretion in how to handle it. The prosecutors might have been more lenient. The judge might have set a reasonable bond. But by doubling down, by defending her actions, by showing no recognition of wrongdoing, Griffin eliminated the possibility of mercy at each level of the system. She essentially forced the hand of everyone involved to treat this with the full severity that the law allows. The question of whether this could have been charged as a misdemeanor instead of a felony is an interesting one. In some jurisdictions with different circumstances, prosecutors might have exercised their discretion to reduce the charge. But in Florida, with this particular set of facts, an adult attacking a child causing injury with video evidence and multiple witnesses, the statute for aggravated child abuse fit the circumstances. The prosecutors felt the charge was sustainable, meaning they believed they could prove it at trial, and they proceeded accordingly. As Griffin sat in her jail cell, awaiting her next court appearance just 2 days before Christmas, the full weight of her actions must have become clear. What started as a mother's instinct to protect her child had transformed into a criminal case with potentially life-altering consequences. The monetary cost alone would be significant. A criminal defense attorney typically requires a minimum retainer of $5,000, and that's just the beginning. But beyond the criminal case loomed another consequence: civil liability. The boy's family would almost certainly file a lawsuit for the trauma inflicted on their child. The emotional distress, the physical injury, the psychological impact of being held underwater by a stranger. All of these would form the basis of a civil claim that could result in substantial damages. And what of the children involved? The 6-year-old boy who was attacked would carry the memory of that terrifying moment for the rest of his life. The sensation of being grabbed from behind, of hands forcing him down, of water closing over his head, of struggling to breathe while a stranger held him under. The panic, the fear, the blood. These are the kinds of childhood traumas that can shape a person's relationship with water, with trust, with their sense of safety in the world. Anne Griffin's own child, who had been dunked by another kid in what should have been just a momentary conflict between children, now had to process what his mother had done. He would grow up knowing that his mother had attacked another child in his defense, that she had gone to jail because of it, that a family vacation had ended in arrest and criminal charges. The case serves as a stark reminder of the boundaries that govern our behavior as adults, and especially as parents. We're allowed to protect our children. We're expected to advocate for them, to stand up for them when they're wronged. But there are lines that cannot be crossed, and physically assaulting someone else's child is so far over that line that the law provides no gray area, no room for justification. It also highlights how quickly a situation can escalate from routine to criminal when emotions override judgment. In the moment, driven by anger and protective instinct, Griffin may have felt justified in what she was doing. She may have thought she was teaching the other boy a lesson, that she was showing him what it felt like to be dunked, that she was protecting her own child by punishing the child who had wronged him. But the law doesn't recognize vigilante justice, especially when the vigilante is an adult and the target is a child. The proper response, the adult response, would have been to find the other boy's parents and have a conversation. To explain what happened, to ask that they address the behavior with their child, to perhaps suggest that both families talk to their kids about appropriate pool behavior and respecting others. Instead, Griffin chose violence. She chose to physically assault a child. And in doing so, she crossed from the realm of understandable parental anger into the territory of criminal behavior. The justice system at every level agreed. This was not acceptable. This was not excusable. This warranted arrest, prosecution, and detention. As the case moved forward, questions remained. Would Griffin ultimately be convicted of aggravated child abuse? Would she accept a plea deal to a lesser charge? Would the case go to trial, where a jury would watch the security footage and hear from witnesses about what they saw? Would she show remorse, finally understanding the gravity of what she'd done, or would she continue to defend her actions? The answers to these questions would unfold in the coming weeks and months as the criminal justice process continued. But regardless of the ultimate outcome, the lessons of this case were already clear. Parents must be the adults in the room. Anger and protective instinct do not justify violence against children. And actions taken in a moment of rage can have consequences that extend far beyond that moment, affecting everyone involved for years to come. The story of what happened at that resort pool is ultimately a cautionary tale about the importance of self-control, about the boundaries that protect children, and about how the justice system responds when those boundaries are violated. It's a reminder that in the heat of the moment, when we're angry and emotional, we must still find a way to choose the right path. Not the easy path, not the path that feels satisfying in the moment, but the path that recognizes our responsibilities as adults in a civilized society. Griffin's case will be resolved one way or another. She'll face whatever consequences the law determines are appropriate. The boy she attacked will hopefully heal, physically and emotionally, though the memory of what happened will never entirely fade. And parents everywhere who hear this story will be reminded of the fundamental truth. We must be better. We must do better. For our children and for everyone else's. If this story resonated with you, if it made you think about justice, parenting, and the consequences of our actions, please hit that like button and subscribe to our channel. We bring you deep dives into real cases that matter, stories that reveal something important about our society and our legal system. Share this video with someone who needs to hear it, leave a comment with your thoughts on how this case should be resolved, and click the notification bell so you never miss when we post our next story. Thank you for watching, and remember, the choices we make in moments of anger can echo for a lifetime. Choose wisely.